Thank you very much for joining me on this review of the hot cases of fraud injunctions during 2023. During the next 30 minutes, I'll be discussing 6 cases and mentioning quite a few others along the way. Necessarily, I'll have to take a light touch of the cases so as to highlight the points of real interest. But some of them, and I'll highlight those that are relevant, will repay further study in your own time. Now, first topic, getting the show on the road. Client arrives with a concern about assets being dissipated, there's been a fraud. It's a pretty manic and stressful time, as you know. Solicitors have to get money on account, get instructions, give advice. It's fast and furious and typically under huge time pressure. Now, all lawyers do know and are alert to the fact that in those circumstances, they have to be pretty focused on where applications are made without notice, the duty of full and frank disclosure. It's rare, although not impossible, that that duty is breached. But it is more common that what is now called the duty of fair presentation is breached. Now, what is this? Well, it's a duty that has been developed over the last decade or so, because the court has little time to consider the papers, will not be reading the voluminous exhibits, and expects the case to be presented fairly by the legal team as a whole, and specifically counsel, but also requires that the affidavit it sets out the case both fairly for and against. That leads us to this first case, Piroozzadeh against Persons Unknown Binance. May last year, the claimant was the victim of a crypto scam. The crypto was traced to 5 wallets overseas held by 2 exchanges. It's a fairly complex case, but in this respect, we only need to focus on Binance. Now, there was no allegation that Binance had done anything wrong in this case. A proprietary injunction was granted, restraining all the defendants from dealing with the crypto. Bankers' trust orders against the 2 exchanges were successful in identifying the users of the accounts who were undoubtedly fraudsters. But the accounts at Binance had long been emptied, by which I mean 9 months before the relevant orders were obtained at the without notice injunction. The claimant alleged that all the defendants held the traceable crypto as constructive trustees. Now, to the extent that the fraudsters had moved it into different accounts, that argument may well have worked, except that the argument was also run against Binance. Binance turned up at the return date and said they wanted to challenge the injunction against them on 2 grounds. First, they said, we're an innocent bystander. The application against us should not have been made without notice. And secondly, that the claimant's legal representatives had failed in their duty of fair presentation at the without notice hearing. So at the return date, the injunction was continued to be listed for a full hearing to decide whether the injunction against Binance should be discharged. So what were the issues? There are the issues. Should it have been made without notice to Binance? The judge said no. He was pretty robust about this. The arguments sort of changed during the course of the hearing. But the main point was, eventually, that it was said there was a risk of inadvertent tipping off. And the judge says, well, that might be right, But that could have been avoided by proceeding against the fraudsters and then serving the order on Binance as a non-respondent. So in other words, get a without notice injunction against the fraudsters, serve it on Binance in the same way as we do with banks. There is no suggestion that where banks have money in an account that may be the proceeds of a fraud, that they should be joined as a party to an injunction. They are simply given notice, and banks, as we all know, are very well aware of exactly what they have to do, and they all have their individual departments that deal with freezing orders. The judge held, though, that this was not a sufficient reason to discharge the injunction on this ground alone. However, it did start to get more complicated. He said, yes, there was a duty, the duty to make a fair presentation of the case was breached, and the injunction was discharged against Binance. Why? Well, first, let's look at what this duty is. It's an obligation to anticipate defences and put them before the court. That one of the many Pugachev cases, we'll touch base on another one later, said that this was a fundamental requirement. But it's also not enough to rely on the judge. It's been said time and again, the judges cannot read all the evidence. They rely heavily on the assessment of the legal team that this is an appropriate case for a freezing injunction, and that the evidence has been summarized fairly, and all the points to be taken into account when exercise of discretion are put before the judge. What happened in this case was quite remarkable. The legal team did not explain what the defences were likely to be available to Binance. What they did do was explain that all the crypto had been swept from the user accounts into a mixed pool. Binance then owed money, owed crypto to each of the account holders. And at any time, an account holder could ask for their crypto and they would be paid out by Binance. But they'd be paid out from a mixed pool from which hundreds of transactions going in and out were being debited and credited every hour, 9 months before the hearing. During submissions, the significance of this pooling had been distorted by false evidence and mistaken submissions that the crypto was actually in the exchange defendant's control. The point being, yes, they controlled their mixed pool, but no, they did not control the user's crypto, because that had effectively disappeared in the mixed pool. Now that, I think, was probably the big point. They also didn't explain why there was a risk of breach of trust to justify an injunction against Binance, or why damages was not an adequate remedy. The point being for us that all of these points have to be highlighted and they have to be dealt with in evidence and submissions. The last one really is a point that arises from the mixed pool. They did not explain how Binance could freeze the traceable proceeds of the crypto in the pooling structure. Now, the judge said, bearing in mind the hundreds of transactions, it would be an essentially futile and close to impossible and possibly impossible exercise. Anyone who sought to trace payments through a bank account knows that it is difficult when you're dealing with a historic account in which there are many transactions. That was all pretty straightforward, or would have been straightforward in the case of a bank. But somehow, because Binance was a crypto exchange, this point just got lost in the wash, and the judge set aside the the injunction. Now, this leads us on to the second one, on the same point, but there is a separate issue in this case. This dealt with a cross-undertaking in damages. Again, we all know at the end of the affidavit, there has to be a section setting out that the applicant will give an undertaking as to damages. What has arisen in the last decade or so, confirmed by a case called Rastogi, is that in an appropriate case, the court can accept a limited cross-undertaking in damages. And this has become quite common when insolvency practitioners apply for freezing injunctions. Mr. Hunt, Stephen Hunt, is a well-known insolvency practitioner. He was appointed provisional liquidator by creditors of an alleged debtor. At the application, the creditors, the application to appoint him as provisional liquidator, they supported the application with an undertaking as to damages in the amount of £200,000. It's a remarkable amount in circumstances where they claimed they'd lost £19 million. That was the amount for which, in respect of which, Mr. Hunt obtained a freezing order against the respondents. And he gave a cross-undertaking in damages. It's worth reading this in full. Limited to the amount of monies and the net realizable value of the unpledged assets of Black Capital in provisional liquidation, taken into the custody or under the control of the applicant in the course of the liquidation, less the costs, expenses, or other disbursements of the liquidation. Well, the Court of Appeal, and it did go to the Court of Appeal, took the view that that was probably, on the material available to them, pretty much worthless undertaking in damages. The undertaking had been accepted on the return date as well as on the without notice hearing. And there was a full analysis of what happened in respect of this undertaking in damages. The Court of Appeal set aside the injunction, relying in part upon the fact that there had been no proper explanation as to why the undertaking in damages was limited. They took the view on the material that there was no sufficient reason to depart from, quotes, the default position that an unlimited undertaking is required. So it hadn't been explained properly why that shouldn't have been given. But worse for us, there had been no fair presentation of the legal position, that the default position was that an unlimited undertaking is required. And in this respect, I'm going to just read what the Court of Appeal said about this. It's been reported in the business law reports. Paragraph 43, quote from the hearing in the skeleton argument, Mr. Hunt offers an undertaking in damages. Since as an office holder, he is not expected to put his own money up, it is submitted that the undertaking should be limited to the assets in liquidation. So that's the ask, but no explanation of why. That was developed further on the same basis during the hearing. And this is what the Court of Appeal had to say about it. They mentioned this Pugachev case, it's yet another one, this time from 2016. Didn't have to mention it by name. But if you're not going to mention it by name, got to be told of the principles, including that the, quotes, default position is that a person applying for an interim injunction must give an unlimited cross-undertaking in damages. that the mere fact that the litigation is being brought by a liquidator of an insolvent company does not compel the conclusion that the undertaking should be capped. It can be relevant to consider whether one or more of the creditors could be expected to indemnify the applicant and whether the liquidator is being funded by a creditor. Counsel should have commented on the application of those principles to the particular facts, drawing attention to the matters, bearing on whether the petitioners might be expected to stand behind Mr. Hunt. Now, the point is that one needs to start with the proposition, the principles that must be applied, and then fairly present the case with evidence and submissions so that the judge who's going to deal with the application at high speed reading, typically fairly high speed decision as to whether to make an order before they then move on to the terms of the order, which can actually often take more time during the hearing. It's a brutal case for anybody who deals with these types of applications. So what do we need to learn? These are the two judgments that I would invite people to read. They do set out exactly what should have been explained to the court. It's enough to scare us all, frankly, and it's a lesson in how to ensure that the evidence and skeleton arguments do present all the relevant facts, full and frank disclosure, but also identify the defences and relevant adverse points for the court's discretion. By way of an aside, Piroozzadeh is not the only crypto case that failed to explain the basis for the alleged constructive trust. Case of Senna in April fell at the same hurdle. Foreign banks in Australia and Hong Kong said there was just no basis for an injunction to be made against them, and the judge agreed. And the costs incurred in that case in trying to set aside the injunction between the two banks were £400,000. So it can get a very expensive exercise in getting it wrong. Next topic, Norwich pharmacal. Now I'm going to whiz through this at some speed. This is really only a takeaway point. The benchmark test is, or has been since 2005 until relatively recently, a test lifted from a case called Mitsui, a decision of Mr. Justice Lightman. And it was a three-part test, three prerequisites. There they are. I won't read them all out, but there needs to be a wrong having been done, needs to be a need for the order, and the person against whom the order is sought must have been in some way mixed up in the wrongdoing, and the authorities deal with each of these points at some length. This has been used as the summary to investigate deeper, as and when necessary, into each of those prerequisites. However, since 2020, we've had what may well be a new test with 4 conditions. The first 3 being threshold hurdles that must be considered before the court gets the last one, which is really a matter of justice. I'm not going to read these all out. That's a quote, and that quote has been adopted. That's a first instance decision of Mr. Justice Husseini, but we will see that in September of the same year, Claire Ambrose in the London Circuit Commercial Court used the same test. Then in the Commercial Court, Mr. Justice Bryan in November adopted the same test. 2022 in December, Mr. Adrian Beltrami as a deputy in the Commercial Court did the same again. And then in October last year, the Privy Council, on an appeal from the Supreme Court of Mauritius, said the following: the board is content to adopt the helpful summary analysis at paragraph 35 in Collier and Bennett, the fourfold test. That's the case of Stanford Asset Holdings. I think that that now is almost inevitably going to be adopted at first instance decisions as the test to be applied, if not by way of a statute, a very helpful summary of the types of things that need to be considered by a court on a Norwich pharmacal. Next topic. Now, this is real fun. It's a very, very short judgment. Joseph Law against Persons Unknown against Huobi. It's a very interesting judgment of His Honour Judge Pelling in the London Circuit Commercial Court. He's at the forefront of crypto recoveries. He's talked widely of the challenges involved in trying to deal with crypto fraud and how the courts need to step up to the mark in order to help as far as they can, stopping crypto being moved where it's proceeds of a fraud, and at best, and trying to help claimants recover. Many of these cases are first instance and undefended. This one typically was undefended, and the exchange, Huobi Global, who I think operates from the Seychelles, although it doesn't say so in this case, was mixed up in a worldwide freezing order against Persons Unknown in respect of 2 wallets maintained by Huobi. Proprietary and personal claims were instituted against the fraudsters, and judgment was entered. Now, the fraudsters didn't get involved. Huobi said that they would comply with any order the court would make. And what the judge did was make a novel 3-stage mandatory order against the crypto exchange Huobi. He ordered that they convert the crypto into fiat currency held overseas. He ordered that they transfer the currency to England, and he left it to be chosen, I think, it was an alternative in the order, either to pay the currency into the court funds office or to the claimant's solicitors to be paid directly into the court's funds office. His preference was the former. But the importance of this was that it brought currency on shore so that it could then be enforced against when held in the court's funds office under CPR 72.10. So quite quickly, this currency, or rather this crypto, converted into fiat currency, paid into the court funds office in England, and then a quick application made to enforce for the benefit of the claimant. It's a fabulous case. And as we will see, this is not the first case in which an injunction has been used for the purpose of enforcement, rather than the more traditional routes, in particular, appointing a receiver. And that was the point picked up in this case last year, Bacci and Green. At first instance, a decision of Andrew Hockhauser, who's not a man known to be shy about making bold decisions, and his decision was supported in the Court of Appeal. The backstory to this is that in insolvency, there is a line of authority, third bullet point here, beginning really with Blight and Brewster, Mr. Gabriel Moss sitting as a deputy in 2012, where a fraudster, and we are, I think at the moment, only talking about or the Bacci case and the Blight case really are based on a fraudster having a pension fund and then wanting to sit pretty on that pension fund, where the poor victim of the fraud is being left high and dry, because the fraudster becomes bankrupt. And in Blight and Brewster, the judge said that the court had power to authorize someone to make an election to draw down on the pension for the benefit of the victim. Bacci and Green took it a stage further. Here, the fraudster remarkably had an £8.5 million pension fund. He had claimed what is called enhanced protection from the lifetime allowance. In other words, maximum pension being in the region of £1.2 million. Now, if revoked, he could increase the lump sum payable from £375,000 tax-free to over £3 million. But that would be taxable at the rate of 55%. The reasons for this are complicated and all to do with the benefits of pensions. Now, the claimant sought an injunction. Thank you to Candy's solicitors who were involved in this case. They took the Blight Authority a step further, because yes, there was a right to elect to draw down the pension, but they wanted the fraudster to notify the HMRC that he was revoking his enhanced protection, so that the amount drawn down was not £375,000, but over £3 million less tax, and so that the creditors would get a sum in excess of £1 million. The point taken was fairly complex, but what was said was, well, we don't challenge the court has power to delegate the right to elect to draw down, but we do challenge that the court, it was said the court did not have power to delegate the defendant's power to notify HMRC that he was revoking his enhanced protection. And that is because the injunction was made under Section 37 of the Senior Courts Act, which says that the court has power to grant injunctions or to appoint a receiver. Now, in the case of a receiver, that power can only be exercised where there is a property or something tantamount to property. And the Court of Appeal said, in respect of the injunction, they did not, it was irrelevant whether or not the power to notify the revenue was property or tantamount to property. And the court had power to grant an injunction. They also said that the court had power to appoint a receiver in the circumstances of this case. So there we are. Both are right. The court has power to delegate the right and to delegate the power. This is very useful. And it's important to take away from this case that where one looks at a fund or property, it's not always strictly necessary to appoint a receiver, which is always expensive and causes delay. The route might be an injunction giving the solicitor control. So don't forget the value of injunctions when enforcing. In respect of the defendant's assets, consider whether the existing assets are where you want them, might be able to bring them on shore, whether they can be converted into different types of assets to make enforcement more likely, and whether potential assets can be created. In the Bacci case, the asset created was a debt. And so an injunction can be extremely useful in those circumstances. Thank you very much. Before you go, it is now 11:30. thank you for attending. I hope you've picked up some points of value in that whistle-stop tour of 2023. Thank you very much, everybody.